On Focus Africa today, our subject, well, it's of a Nigerian origin, but has big African implications. Now, for years, Diezani Alison-Madueke symbolized power, privilege, and also unanswered questions. Now, her trial has reopened conversations around corruption, accountability, and trust in public office. Allegations include luxury spending, bribery, and also abuse of office during her time as Nigeria's petroleum minister. Beyond the individual, the case speaks to a larger issue. Can high-profile corruption cases finally deliver justice, or do they only remind citizens of how long accountability takes?
Now, to examine the legal process and the wider implications, we are joined by Adeniyi Kunu, international journalist and researcher.
Oh, I beg your pardon. We were supposed to be joined by Adeniyi Kunu, but instead we have a substitute. I'm sorry, I should have told you that from before. But we have with us Tobi Balogun in the studio, legal practitioner. And of course, we also have Tohwo Oseruvwoja joining us via Zoom. Tohwo, welcome and thank you very much for joining us on short notice. Do I give it back to you if you want to fire off the first question?
Put my words back in my mouth. I'll start with you, sir. Thank you so much for joining us.
Thank you for having me.
My question to you is, what are the key allegations Nigerians should pay attention to in this trial, and how strong is the evidence as publicly, displayed right now?
The trial in the UK, the crux of the trial in the UK is basically bribery allegations against the former minister. That's counts 1, 2, 4, 5, 6, and I think 7. Are alleged that she received payments that she ought not to have received in the course of her responsibilities as minister. However, the trial, having commenced, has shed more light on a lot of things that I think Nigerians should pay attention to. And it's also sort of backtracks to us, even as Nigerians, because the trial, everything that has happened in it, the players, the alleged people who paid the bribes to the minister, where most of the incident occurred were in Nigeria. It was during our time as minister, as a minister of the Federal Republic of Nigeria. So it doesn't necessarily make so much sense that the trial is even happening in the UK to begin with. So it makes us come back. It requires us to come back home and take a look at ourselves as to why is this happening in the UK? Because the entire incident, which is the crux of this trial, occurred between 2011 and 2015, and this trial has only commenced in 2023. With proceedings happening in the last couple of days, earnestly. And in the course of it, you have to also understand that the people who have allegedly paid bribes to the minister are not before the court. So how exactly are you going to establish that these bribes were paid? Is there a word, maybe some interviews were conducted earlier where maybe investigations and everything revealed that bribes were allegedly paid to the minister? But as it is, these people are not before the court. How is the minister, or how is even the prosecution supposed to prove its case that these bribes were paid when the people who allegedly paid the bribe are not in court? So it's going to be a very interesting one up to when the decision will be handed down, because as a criminal defense attorney myself, I've been involved in cases where, for example, there was a trial I did sometime last year where it happened that people who, lower cadre staff, they played a minor role in the whole incident. So the prosecuting agency packed all of them and brought them to court. The judge found at it that these are not people who make decisions in this company to have effected this kind of allegations against them. Why are you not bringing the main people before the court? Ultimately, I can't really go into details, but ultimately we won the case. It's on appeal now, I can't. But the fact that these people are not in court is going to really, from my own experience, is going to really hinder the prosecution establishing the charges before the court.
That's a very peculiar note to raise there, Mr. Balogun, because in this case, Diezani has pleaded not guilty.
Yes.
So exactly how would the court have to prove, beyond public suspicion, just public suspicion,
yes,
how would they prove that she is guilty? What lies before them? What effort lies before them to prove that she is absolutely guilty?
So now,
and Tohwo, we are coming to you. Apologies, but I wanted to jump on that train.
Okay, so you would understand that it's a criminal trial. So it's not necessarily it's not the court of public opinion. It is what is before the court. And being a criminal trial, they must prove this case beyond reasonable doubt. Of course, it's not like beyond any doubt per se, but it's just beyond reasonable doubt. And this is what I'm trying to say. The issue of having to prove this case beyond reasonable doubt is what is the possibility of being able to, assuming that even these things occurred and everything. You said some individuals paid bribes to the minister, and the bribes influenced, or you said the bribe were not supposed to have been paid. They were paid, they were allegedly paid, and you didn't bring these people to court to come and say their side of the story. If they paid, even give the former minister the opportunity for our legal team to cross-examine them as to maybe these alleged payments, what were they for? So now it's just the word of the prosecution that payments were made, and that was it. And also, you have to also understand, I've gone through the prosecution opening statement, and even in the prosecution opening statement, whilst they insist that bribes were paid to the minister, she took financial advantage, allegedly. In the same statement, the prosecution said there's no evidence before the court to show that these alleged sums allegedly received influenced the minister's job to award the contracts to entities who were not supposed to have the contracts in the first place. So you have to ask yourself, you have to come back and ask yourself that what really are we really doing here? If you said she received the bribe, but the alleged bribe, there is no evidence before the court, there's no evidence on the side of the prosecution to show that these bribes influenced our decision to award contracts to people who were not supposed to have contracts in the first place. So it's going to be an interesting one, which of course I'll be following closely, but there are other issues there. For example, you know...
Well, I'll let you give that example, because I want to ask Tohwo a question.
Oh, please, go ahead.
Tohwo, you're still there with us. Now, Tohwo, let's take a look at exactly why this is happening outside of Nigeria and the implications here on our justice system. I'm wondering why exactly, or what implications it has, where the Nigerian justice institutions are unable to try or even try these high-level corruption cases. What does it say about our justice system?
Let me first of all make one issue clear when it comes to issue of bribery. And I've been privileged to practice in Nigeria as a lawyer and also as a defense counsel. And I've been privileged to observe processes, criminal proceedings here in the UK, which I'm currently based now temporarily. And I'll tell you, as a matter of fact, when it comes to issue of bribery, both in Nigeria and in the UK, if you look at the theory about bribery, you discover that the giver necessarily must not be part of the process. As a matter of fact, the prosecutor is at liberty to charge whoever he wants to charge, either the giver or the receiver. What should be the base and position for the conviction is the circumstantial evidence, which the opening statement which I've read would have stated clearly. The first question would be the homologous amount of money and what is that money for? And if you look at the bribery regime in the UK, there's every tendency that conviction may be secured. Then when we look at it from the perspective of the judicial process here, you discover that this matter in question happens, Diezani Alison-Madueke was petroleum minister between 2010 and 2015. And you also recall that he became the OPEC chairman between 2014 and 2015. So if you look at it holistically, between that time and in 2023, when the UK government picked it up, you discover that there's been an holistic investigating process. Here in the UK, investigation takes longer than the court process. Then looking at it in a Nigerian judicial process, you discover that we have more media trial, we have more of reliance on the statements of the defendant. If you look at most of our judges, most of our judgments on criminal cases, on all cases, are based on not independent investigation of security agencies or law enforcement agencies or the prosecuting agency. Is more or less on statements accrue from the defendant. So the court is tied. We just cap up issues, we take them to court, and it's even when they are in court, investigations are being made. It's even on television, we get to know, oh, this. So there's every tendency of high level of compromise in such processes. So that is the implication. We should not be looking at the judges. Basically, we should be looking at the prosecuting arm of Nigerian government, what they do before bringing matters to court. So that should be the larger picture of the issue.
I mean, it's quite clear that it's going to be a complicated and a challenging case, but I'd like to hear from you, still on you, what jurisdictional challenges can complicate this case?
Well, basically, there is no, when you look at issue of the bribery, and if you look at the evidence thus far that is between the public domain, you discover that the said money in question, one, what you should know is a minister of petroleum. First of all, you should look at it. She's the minister of petroleum. Then she's also the head of the OPEC, which is an international organization. Then if you look at what the UK government is saying, they are not charging her on the alleged money laundering cases in Nigeria. They are only talking about issues that happens within the territory of the United Kingdom. And here in the United Kingdom, I'll tell you as a matter of fact, yeah, money can be paid to you for the purpose of influencing a decision in Nigeria. The question when it comes to the intelligence gathering on that particular amount of money, here deals on accountability, here deals on data. So when a money leaves your account, basically, there must be a trigger point from the financial institution. So what they are saying is that if you look at evidence thus far, at the fact that the said money, the 200 million pounds they are talking about, was spent here in the UK, was given out in the UK using the credit card or the debit card of one of the giver in question, which can be seen as an accessory. So it depends on the bargaining tools, because issue of financial crime, bribery, they also in the UK, they practice what we call the plea bargaining system, whereby they may concede to some level of withdrawing the giver or pleading for a lower offense in this regard. So there is no jurisdictional change, but the other level of it is the fact that in Nigeria, that question, that subject matter, which is tried in the UK, cannot be resuscitated in Nigeria. Like I told you, any transaction traced to that 2 million pounds that she's been tried here in the UK cannot be tried in Nigeria, but that does not elevate her from every other bribery and corruption cases in Nigeria.
Okay. Okay, you
if I can just interject, why is that? Why would it not be possible for those charges to be tried in Nigeria? Because she was the minister in Nigeria.
Now, the question is that what are the information in, let me make it clear, though it's a bribery cases, but if you look at the Money Laundering Act regime, generally, internationally, it has no jurisdictional restriction. That is why you see the former governor of Delta State, James Ibori, was tried in the UK when such amount of money was traced within the territory of the United Kingdom. It has no jurisdictional listing. There are two things United Kingdom would have done if they have full confidence in Nigeria judicial system. Is one, is either to partner with the EFCC or ICPC and forward the details to them. That is on their own discretion. But they can also prosecute her because that said amount of money is within the territories of the United Kingdom. A good example, I had an experience whereby I record a particular amount of money from Nigeria, from my Naira account in Davat, and immediately entered my UK account. The account was placed. See, I provide explanation because obviously it has left the borders of Nigeria to the United Kingdom. That has a financial prudent, investigative, and analytic process. So until I provided evidence, that was when my account, my bank uplifted that disease. So it's within the territories of United. You could see that all the transaction that was done, the hotel she stays and every other thing is in the UK. Now, what will now happen if that money is recovered? Yes, it will now become a bilateral relationship between Nigeria and UK to see that money will be repatriated. But as it is, this is within the UK system.
Okay, thank you very much, Tohwo. Back in the studio here with us, Tobi. I wanted to know, since we're on the subject of her finances and all, let's talk about how pivotal the allegations of luxury spending are to this case. Exactly how pivotal is that for the prosecution? Why does that matter, luxury spending and the gifts because that's mostly how most people came about or are aware of the case, especially in a country where you have very short attention span. Once you talk about high-level spending, luxury, you've caught people's attention. Why is that pivotal here in this case for the prosecution? So,
flowing from what my learned colleague said earlier, you have to understand that I think he's maybe conflating the issues. The issues before the UK is not necessarily money laundering or anything, it's bribery. And the kind of bribery, there was barely any alleged payment exchanged via cash. It was alleged that she went to our roads, she went to several luxury stores, and items were acquired on
These
her
were
behalf.
gifts.
They were gifts. So there has to be a difference. We have to establish what we are talking about. There were gifts. There were alleged gifts that were given to her or allegedly acquired on her behalf.
Okay.
So it wasn't like maybe she took money from, according to what is before the court again. I'm strictly talking based on what is before the UK court as it is. What is before the court is that certain individuals acquired several things for her, houses where she was using, furnished it for her. She stayed there, they were all luxury apartments, luxury shopping, expensive shopping and everything. But there was no cash gifts necessarily exchanged between the parties. So now, why we have to also...
And this is criminal, why?
That's the bribery.
Okay.
The
So
like I
instead
said,
of monies, we're going to give you
exactly.
untraceable
Thank
funds,
you.
untraceable items.
Allegedly.
Allegedly.
So that's the point we have to establish. There was no money necessarily exchanging hands. It was an accusation. There were accusations of going here and there, buying luxury stuff. So now there's also an issue that has come up in the course of, as at yesterday, the defense team for the minister was, in the course of the trial, established before the court that within 2011 and 2013 or 14, the minister was not in the country as at some periods when certain commodities or certain items were purchased. So now what the prosecution is trying to do, from my own understanding and from the records before the court, is more or less like this individual bought all these things and the prosecution is trying to pin it on the minister. So now the minister was not in the country for like a period of time and these
So you
items...
can't pin it on her.
I'm not saying that.
Okay.
That's the case of the
what-
prosecution.
yeah.
That is
That's the
what is
defense
before the
they're
court. So now, you are saying that all these things were acquired on behalf of the minister, for the use of the minister. But within certain period of time,
She wasn't
when
even
she
there.
wasn't even in the country, her passport records were tendered to show where she was as at the time these things were being done. And yet, we were expected to just assume that everything that was bought within that period of time, the entire investigation period, was done on behalf of the minister. So these are the issues why I think, again, it would have been necessary for the individuals who are also involved in this thing to be before the court. Because like I said, I believe it is very important because it is practice. You're supposed to establish the connection between these things. It's just the word of the investigators. Let them come to the court and say, okay, we paid this money. It was for so purpose. And again, I have to go back to the point I made earlier. The prosecution statement says that there is no evidence before the court to show that these payments were influenced, these payments influenced the minister's decision to the advantage of the individuals that allegedly paid this bribe. So it comes back to the same question I keep asking. What exactly are we doing before the courts? Also, the defense, usually in criminal proceedings, one of the very essential elements is fair hearing. So the minister has been stuck in the UK since, I think, 2015 or so. She hasn't been allowed to return to Nigeria. And in the course of the allegations against her, part of the defense is that most of these things that she's been accused of buying, purchasing, acquiring, were reimbursed. They weren't even necessarily to our own gain. They were reimbursed. I'll give an example, and this is before the court. I'm not saying anything outside what is before the court. There was a payment, an alleged payment of about maybe £6,000. It's in the opening statement of the prosecution. That was paid for us, so allegedly paid by one of the people who paid the bribe, who allegedly paid the bribe, as school fees for our son. Yes, allegedly, or school fees or something, or placeholder, something about school. The funds were reimbursed to the payer because the payment was paid by the minister or someone else. The point I'm trying to say is that the minister has the defense she could have relied upon, saying that there are evidence that this payment, these alleged payments or these alleged purchases were reimbursed to the people who made them. But she hasn't been allowed to return to the country to probably lay her hands on maybe some of these documents or some of this evidence to show that these things happen. But on the record there was an example of something like that where the payment was reimbursed to the payer. So the point I'm trying to say is I don't want to jump into conclusion because I'm not the judge and I'm not one of the defense counsel on record, but it's going to make for an interesting case, especially when the decision is eventually handed
absolutely
down.
interesting. Tohwo, I'm sure you have something to say because we're almost out of time, but if you have anything to add to that, I do have one last question for you, so be summary in this submission, please.
Okay, well, what I just wanted to clear is the fact that bribery necessarily, there was no misconception on my earlier submission. Bribery is not necessarily be money giving, it can be other incentive. So you must not necessarily be in the UK for the purpose of that bribery items to be passed across. I may be, a good example, I may be in Nigeria, I may be in the UK and ask somebody, okay, you want to do this, I want you to do this for so-so person. But in the influence of a return or for the purpose of favoring or influencing my decision. So the question would be, yes, who instructed the giver to give the person? I am the one. And to what benefit is that? If I promise to give you in the studio now 1 million naira, for the purpose of my own contribution, and I ask a third party to give you or give you a car, it must not necessarily be money. But just like he stated earlier, we want to see the perception, that is the outcome of the trial. But in a bigger way, is something we all need to learn when we look at the investigative process in Nigeria. It's a process that took time.
Okay,
the court process will be so short and brief.
All right, Tohwo, so now final question to you. How does political influence, whether past, present, or even future, how do they normally affect these kinds of cases of this magnitude?
Let me give you a good example that is within the public domain. You look at the one of former governor of Kogi State. You agree with me, Yaya Bello, you agree with me that before the EFCC chairman came out openly to say that if he did not prosecute Yaya Bello, he will resign or something like that, in a situation like that. But you could see that at that particular point in time, there were rumor and silent observation that the relationship between him and the presidency are not in good terms. But when such thing has aligned, when he was made a member of the committee, you discovered that the cases that the EFCC chairman rushed to court, rushed to the media to open all evidence, that we all believe that even the case will be done within 1 day or 2 days, and Yaya Bello will be convicted. You could see where it is now. We could mention so many cases you can ever think about. You see the one of the former governor of Kano State.
Yep, but this is a case outside of Nigeria. Do you think that it will have the same impact, like the political?
No. As a matter, okay, when you talk about outside Nigeria, it has no politics. There can never be any influence in that regard. The only thing I believe, Nigerians will be looking at now is the outcome of the case. And you can see that Nigeria has made several efforts to see how the former deputy senate president can serve his president, and he was declined. So this cannot be influenced.
Okay, fine. Tobi, do you agree?
Yeah. I do not necessarily agree totally with him. So now, which also does tail into
You'd have to be very summary because we're out of time.
Like I said, there are a lot of individuals that played individual roles in this whole entire transaction. But right now, it is the minister who is being singled out. And I believe that is because of her position as a minister and her position as a member of probably the regime before Buhari's regime. So if, again, I believe they want to do a thorough case, all the individuals, if you are paying a bribe, paying a bribe to someone is an offense. If you are receiving a bribe, it is an offense. So how come the alleged payers of the bribe are not before the court, and only the alleged receiver of the bribe is before the court? And you say that there is no some sort of influence in what is before the UK court as it is. We like to, castigate our judiciary and everything, but like I said, I was opportune to be in court once, and the judge was quite upset that your case is not thorough. You can't bring all these individuals to court without bringing the other people who played active roles in this. And this is the point I'm still standing on. And I believe that based on this, we'll be following up with the case and see how it goes eventually.
Indeed, we will. Thank you very much, Tobi.
Thank you very much for
Thank you very much, Tohwo, for joining us, especially on short notice. And we'll be expecting the 1 million naira you've promised, or the car.
No, I didn't promise that.
We kid.
I'm passing it to my colleague to do that for you.
Okay, there we go.
I didn't make any promise.
Thank you, gentlemen. Thank you indeed.
Thank you very much.